Hello, everyone. Welcome back after the lunch break. Hope you all had a lovely lunch. At the Bangalore venue here, we had a very constructive conversation about some of the ideas that were discussed in the previous sessions while enjoying sumptuous 100% plant-based offering. I'm Apurva. I'm the founder and director of Animal Law and Policy Network. We're co-organizing this event along with Asia for Animals Farm Coalition, Samayu, Animal Law Center, and Fish Welfare Initiative. Welcome to our next session, which is a keynote address on the theme Animals in Social Justice Movements, a cause we cannot ignore. I have the pleasure of introducing our keynote speaker, Ms. Ashwini Vaidialingam. Ashwini graduated from National Law School of India University, Bangalore in 2016 with a BA LLB honors, and from the University of Cambridge in 2017 with an LLM. She has been litigating since, initially at AZBN Partners Dispute Resolution Team, and for the past 6 years as part of the chambers of Surit Parthasarathi and Arun Kartik Mohan. She has recently set up her own independent practice, PNV Law Chambers. She primarily practices public and commercial law and has represented various animal rights activists and organizations before the Madras High Court. A very, very warm welcome, Ashwini. The virtual floor is all yours.
Thank you, Apurva. Good afternoon, everyone, virtual and physical. It's a pleasure to be here. I would like to thank the organizers for inviting me to deliver the keynote speech on animals in social justice movements, a cause we cannot ignore. As Apurva said, I'm a practicing advocate, and the perspective is therefore that of a lawyer, as opposed to an activist or somebody who's engaged in animal rights advocacy on a day-to-day basis. And I just wanted to say that my perspective as a lawyer will therefore inform the speech that I intend to make. So animals and social justice movements. Traditionally, when one speaks of social justice, one speaks of human rights, equity, fairness, and dignity for all people, regardless of race, gender, or socioeconomic status. And mainstream social justice theory, and by that, I'm referring to the philosophical foundations for modern mainstream social justice theory, is almost entirely anthropocentric. That is, it's human-centric. For instance, John Rawls, who has an outsized impact in the field, has argued that although we have duties of compassion and humanity towards animals and should refrain from treating them cruelly, he nonetheless felt that animals are outside the scope of the theory of justice. And of course, it's not static, and these conceptions have been challenged. Peter Singer needs no introduction. Martha Nussbaum is another vocal proponent for a philosophy of justice that includes animals. This anthropocentrism, that is a human-centric approach to social justice, is deeply, it's reflected in the Indian legal system. If you examine the Constitution of India, it guarantees fundamental rights or inalienable rights only to human beings, and a majority of those rights only to citizens. When it speaks about animal rights, it only talks about it in the directive principles of state policy, which are non-binding, non-enforceable. For instance, Article 48 speaks about the state's efforts to organize animal husbandry by improving breeds, and it encourages the prohibition of cattle slaughter. So it's a very specific vision of animal rights. Article 51A, which is the fundamental duties introduced during the emergency in the 1970s, obliges citizens to have compassion for living creatures. So again, it's an obligation on the human, on the citizen of the country. The animals themselves are only objects in the conversation, not seen as actors with agency themselves. Apart from the Constitution, the Prevention of Cruelty to Animals Act of 1960 is the key legislation in India in relation to animal rights. It is similarly anthropocentric. Rather than recognizing animals as beings with inherent rights, the PC Act primarily protects them to the extent that their suffering is deemed unnecessary or excessive by human standards. That is, it does not challenge the use of animals for human benefit, whether in food production, in the course of science, or for entertainment, circuses, for instance, but instead it regulates how they are treated within these larger exploitative systems. For instance, if you look at Section 11 of the PC Act, it criminalizes cruelty, but numerous exceptions allow animals to be used for work, for slaughter, for testing, as long as certain prescribed guidelines are followed. This legal framework, therefore, does not recognize animals as rights holders in themselves, as actors in a conversation on justice, but rather as resources that humans must use in a humane manner, with their interests and their needs as secondary to human needs. Now, this being the legal foundation from both a theoretical perspective and from a practical perspective, it is a matter of fact that social justice movements not only do not, but also cannot always account for animal rights. The conversation about animals is not something that is absent, it is something that is perhaps disabled by the law. And as a consequence, courts in India, which, as we all know, are critical institutions in social justice movements, also do not or cannot deal with animals the same way they deal with other actors in social justice litigation. And the key question when you're having a conversation about courts and litigation is of standing or locus standi, the right of a person to approach a court. Now, one example of this is in tracing missing wildlife. For instance, you have endangered species like elephants, very common in the Nilgiris, that are tracked, particularly the male elephants. Now, when these animals go missing, and often there is local foul play there is use of barbed wires or bombs or even state complicity in poaching. When these animals go missing, there is no remedy that is immediately available in the way that is available for human beings who go missing. That is, I cannot file a writ of habeas corpus. I will have to file a public interest litigation. A PIL is a kind of litigation where the motives and the interest of the petitioner will always be under question. The question is always, who is this person who is seeking to represent the animal? And that often dominates the scope of that litigation and its destiny. The animal itself is voiceless. So this place that animals hold in our understanding of social justice in India and in social justice movements, it also means that in any exercise of balancing interests, human interest will always trump animal interest. Now, for this, if you look at the PC Act itself, Section 28 explicitly permits the killing of animals for religious purposes. Therefore, questioning animal sacrifice in Indian courts, which are often done in a inhumane or cruel manner, it's always a fraught exercise. Because the minute you have a question of tradition or culture or religion, human interest invariably prevails. An anecdote that I can share is we recently represented a person who had complained about a social media video that had gone viral of a Jallikattu bull being force-fed a live rooster. It was very graphic and very horrible. And while initially an FIR was filed against the people who committed that act of cruelty, both against the bull and against the rooster, eventually the courts found that the perpetrators, were under the belief that this would cure foot and mouth disease. And it was a traditional practice in that village to engage in such an act to cure the bull. Now, despite the fact that science has answers for foot and mouth disease, the mere fact that there was a traditional practice meant that the animal cruelty was overlooked. So, given in this context, one way of looking at animal rights is the view taken by the Indian Supreme Court in Animal Welfare Board of India versus A. Nagaraja, which is the judgment that led to a brief ban on Jallikattu. Article 21 of the Constitution says that no person shall be deprived of life or personal liberty except according to procedure established by law. So the question was whether Article 21 could apply as against animals, because as you may have noted, the right is granted to the person who should not be deprived of his life or personal liberty. Now, the Supreme Court holds on a reading of Article 21 that life means something more expansive. And specifically, it says, and I'm quoting, so far as animals are concerned, in our view, life means something more than mere survival or existence or instrumental value for human beings, but to lead a life with some intrinsic worth, honor, and dignity. Eventually, the court holds that these principles have to be read into the PC Act and also Article 51A G, which requires us to have compassion for animals, to ban Jallikattu. It's a matter of fact that subsequently this was legislatively overturned by an amendment, and the Supreme Court has upheld that amendment. So Jallikattu is now legal, even though there is, I believe, reviews pending in the Supreme Court. So Nagaraja, in that sense, has been overturned, but the principles that it lays down on the rights of an animal are arguably still good law. In 2020, the Uttarakhand High Court, while relying on Nagaraja in the context of cruelty to horses, held that the entire animal kingdom, including avian and aquatic species, are legal entities having a distinct persona with corresponding rights, duties, and liabilities of a living person. And they held that all the citizens throughout the state of Uttarakhand are hereby declared persons in loco parentis as the human face for the welfare or protection of animals. So while they don't recognize the animal as having the right to approach court or as being voiceless, therefore, they find that all citizens of that particular state where the court has jurisdiction will be in loco parentis or in a position of trust in respect of the animals. These sort of expansive views that recognize animal dignity or create a framework for enforcement of animal rights does mean that one can include animals in a larger conversation on social justice movements. You can seek to include their rights, their concerns in a broader animal justice, in a social justice fight. But from a practical perspective, the minute you try to enforce or seek remedies that are beyond declaratory reliefs in the nature of Nagaraja or Narayan Dutt Bhatt in the Uttarakhand High Court, you will run into problems. So, for instance, if you, in a specific instance of animal cruelty, or even with respect to, say, let's say the use of birds in circuses or the use of dogs in circuses, which are forms of cruelty. For instance, if you look at birds in circuses, typically their wings are clipped and the natural life of a bird is completely upturned. If you want to, as a social justice movement, if you want to say, try to enforce the rights of these birds, the immediate problem you will run into is the PC Act sits on the existing criminal justice machinery. That is, to enforce rights, you have to make a criminal complaint, and it is the magistrate's court which will deal with such complaints. And by its very nature, criminal law has to be applied strictly. So you cannot argue broad rights like the way the Supreme Court does in Nagaraja or the Uttarakhand High Court does. You have to argue very narrowly, and you will fall within Section 11 of the PC Act, subject to all of its exceptions. And there are a lot of exceptions. So without substantial amendments to the Prevention of Cruelty to Animals Act, the fight for animal rights in any, the fight for animal rights per se or including animals in any social justice movement will be limited in nature. Therefore, the point I'm trying to make is that the exclusion of animals from mainstream social justice movements is not accidental. It is deeply rooted in anthropocentric legal and philosophical traditions. And while courts have attempted to shift the conversation by talking of animal rights in whatever framework exists, the fact is that that underlying framework is restrictive. And while amendments have been proposed to the PC Act from time to time, they do not propose any alteration to this underlying worldview, which sees animals not as rights holders, but objects of human responsibility and regulation. And this presents, therefore, a significant challenge to integrating animal rights into broader justice movements. But I'd like to conclude, however, by saying that history shows that this is not insurmountable. What was once considered radical, like anti-caste movements, gender equality, environmental justice, are now fundamental to our collective morality. And the expansion of justice to non-human animals is not just an ethical imperative, but a logical progression. Because true justice cannot be selective. And if we are committed to principles of fairness, dignity, and equity, then animals as sentient beings capable of suffering must be a part of that conversation. Therefore, it is a cause we cannot ignore. I'm open to questions now.
Thank you so much for that, Ashwini. That was really, really insightful. I think, your mention of how a thinker is well recognized as John Rawls felt that animals were outside the scope of social justice. Thank you for mentioning Peter Singer and Martha Nussbaum. If anyone in our audience is not familiar with their work, Animal Liberation Now has come out after 50 years since the original text was written. So highly recommend that book. And yeah, I think there's one thing that has always stayed with me from Animal Liberation, where Peter Singer talks about equality is not equal treatment of all, it's equal consideration for all. So I think my question to you is going to be based on that. Do you think the law in India as it stands today gives equal consideration? If not even equal, does it even give consideration to animals as possible right bearers? And another alternate, just sort of an additional question I'd like to add to that is, do you think there is a scope for constitutional recognition of rights for animals within the Indian legal framework?
So to answer the first question, given the way the Prevention of Cruelty to Animals Act is structured, I wouldn't say consideration is the word. I would say that it's a bare minimum threshold that the Act sets for preventing unnecessary or unusual cruelty. And even the way amendments have been proposed from time to time, they like talking points will be things like bestiality. They will not be things like use of more humane. So, for instance, bulls have they have this concept of nose roping. Now, nose roping of bulls is cruel, and there are humane alternatives, but those will not be part of the conversation. The conversation is not about shifting to improving dignity of animals. It is usually more preventative in nature. Let's avoid bestiality, for instance. That seems to be the tenor of the conversation.
And about constitutional rights for animals?
I think that's quite a political question. I think it will be difficult because the way Chapter 3, Part 3 of the Constitution is structured, it is human-centric. It will require quite a significant change in the very conception of fundamental rights in the country for to bring in the kind of change that you're talking about.
Completely understand, and I think that's where we talk about and we thought about animal rights from a justice lens, because when we talk about justice, we can talk about the vulnerable, and who's more vulnerable. There are more vulnerable. Animals are a vulnerable category of the inhabitants of this earth. So there are some questions from the audience. I have a lot of questions, but I will take the audience questions first. So Manisha says, how do you think we can get these underlying restrictive frameworks changed for animal rights? What can the animal protection community and activists do to bring about such changes?
So the PC Act is a 1960 legislation. It is prior to a lot of change in the way justice itself has been understood. Peter Singer's work, for instance, has transformed the way animal ethics are discussed, and it's much later to the enactment of the PC Act. And I think an overhaul of the entire statute would be required. The way it's structured, the mechanisms in place, the kind of rules that it envisages, it will require a fundamental overhaul. Perhaps uh, speak to your member of parliament.
Right. No, I completely get your point because, when we look at the Prevention of Cruelty to Animals Act, it's
Yeah.
one of the rare welfare legislations, and I don't even, a lot of
Yes.
people argue that it's not even a welfare legislation, it's an anti-cruelty legislation. Uh, but if it's the closest we have to a welfare legislation. And a lot of people argue that, there are very few welfare legislations around the world where, which permit exploitation of animals in the way the PCA does. For instance, the act itself creates an entire regime that prescribes how experimentation on animals needs to be conducted. So it's very clear that the legal regime, if there has to be space for animal rights and animal justice, the legal system needs an overhaul.
Complete overhaul, yes.
Yes. So another question that we have from one of our audience members, Tushti, isn't sentience a defective criteria for social justice? So what could be challenges in molding the animal protection movement as a social justice issue?
I agree, Tushti, that sentience is arguably a defective criteria. But I think I think sentience is the answer to the question, how do you determine cruelty? Because is cruelty suffering of the person on whom cruelty is afflicted on? And is therefore sentience something required to determine cruelty? But perhaps the question is, does life itself warrant such treatment? Does a higher threshold of is a higher threshold of sentience warranted? Very frankly, I don't have the answer to that.
No, completely agree
Yeah.
with you there. I think as far as looking at how the animal protection movement, and I can take that question a little bit
Yes.
because I've thought about it a lot. How do we build these bridges with other social justice movements? I think the animal protection movement for the longest time was very inward looking, in the sense that we felt that if we talk about any other issue than animal welfare, we are diluting our cause. So if we talk about the link between child abuse and animal abuse, that's diluting the cause because the focus shifts from the animal to the child. If we talk about labor rights in poultry farms, for instance, that shifts the focus from the birds that are being exploited in the poultry farm to the people involved in working there, and often who might be responsible for the mistreatment of some of these animals. And I think the idea that of looking at animal justice, animal welfare as a social justice issue, also at least within the movement, there was a realization that it's not working. This isolation just means that there are these wonderful movements that have done so much to advance so many other issues in our country, and we haven't made as much progress as they have. So what can we learn from them? And are there any commonalities that we can work towards? I can give you an example of the link between the child rights movement in the country and women's rights movement in the country and the animal movement. Now, there are multiple studies to show that women in abusive relationships are hesitant if they have a pet in the household, are hesitant to leave that relationship. And this has been proved by a lot of studies. But the shelter homes that we have in India don't have any provision for keeping these animals. And as a result, women stay for a longer period of time, like till they can no longer bear that situation. So, yes, I think there is a lot of merit in trying to reach out to other movements and trying to say that we're all on the same side. We're all talking about the vulnerable. We're all talking about those who have difficulty in accessing justice. So,
And
yeah.
to just add to that, I think that from a lawyer's perspective, courts are chock full of human problems, like gross human suffering at a scale, and I think judges in particular see the worst of humanity. And in that space, to talk about animal rights, dehorse of counterbalancing human rights, tends to be atonal. That when you are dealing with 50 women who have been brutally assaulted, someone talking about a dog having been stoned, it just does not land right, even though that they are not comparable and they should not, those are cruelties that should not be compared, or they are equally capable of being dealt with compassion and understanding. I just think that as a systemic issue, it strategically combining these two things is always a tonally, optically, a better strategy.
No, I completely get your point. I think I think as a movement, we have to be more careful about understanding our audience and doing our research into
Yes.
who our audience is, because sometimes we might end up doing more harm than good by using a particular strategy. And I think we've gotten better at it. I think due credit to us where it's due. We've definitely got
Definitely.
better at you know uh, uh, customizing our messaging to the audience that we're targeting. And I think especially the links that we're finding with environmental justice, like since this is a farm
Absolutely.
animal coalition event, just the environmental um, degradation that is
Absolutely.
enabled by factory farming is
Yes.
something that is an issue that we need to talk about. And that doesn't mean we're taking it away from the animals, right? That doesn't mean, I think that understanding that we're all in this together and that we're part of a movement, I think that is something to keep in mind at all times. I just had one last question from the audience because we're running out of time. So
Sure.
someone said that this is Manisha saying that if even no more 50 campaigns are taking so much time to impact changes in the Prevention of Cruelty to Animals Act, in spite of support from many MPs, what can we do in the here now? Or is this something that is simply not worth pursuing in these times?
I certainly hope not. I hope that continue to pursue it regardless of the times. Um, it is a political reality. I mean, it is a question on political realities that there seem to be other priorities for Parliament, for um, people in power, and as a lawyer, I don't know if I'm the right person to be asking the question on what is the best way to uh, effect legislative amendments. But I would assume that the answer lies in advocacy and in grassroots movements and in creating consensus. And even if the issue is not seen right now in this whatever parliamentary session as critical, that in a year or two, if you manage to create that kind of consensus, it will be seen as something that's relevant. And I mean, I would think that there are strategic overlaps in, let's say, um, cattle protection laws that could be looked at by animal rights activists. I mean, regardless of one's politics on it.
Right. Thank you so much, Ashwini. Thank you so much for taking out the time and talking to us about this important issue. I think animals in law is just a topic that many are hesitant to discuss, but I think the law is a very, very powerful tool of social change. And it's not just about what a law says, right? It's not just the bare text of the law. It's about the message it sends to society. So, there are quite a few questions about the prevention of the draft amendment bill.
Right.
And I think all I would say to our audience with respect to the amendment bill is it is progress. It is definitely a movement forward. We need an overhaul, as we discussed. We need a lot to change. We need the underlying foundation for animals to be considered as part of social justice, animal welfare as a social justice issue. But till we get there, I think we need baby steps, and we need to sort of take push for change to the extent possible. And yeah, with that, we come to the end of the discussion. Thank you so much, Ashwini, and it was lovely to have you here. Thank you so much.
Thank you so much.